All right, welcome everyone to this webinar on modern slavery and supply chains. It's an international perspective for Canadian companies. Today I have the pleasure of being joined by my colleagues, Kristy, Balsanek, and Katie Hausfeld. Kristy is a partner at DLA Piper in Washington and is the global co-chair of the Environmental, Social, and Governance practice. She has over 20 years of legal experience. Kristy specializes in sustainability and ESG advisory services and supports clients in transitioning towards long-term value and sustainability, focusing on regulatory assessments, reporting, climate transition, and supply chain due diligence. Kristy has counseled numerous multinational companies across various sectors, including healthcare, industrials, and consumer goods, on global sustainability and ESG compliance. We also have Katie Hausfeld, who's a partner at our DLA Piper Chicago office, and who focuses her practice on corporate investigations, compliance, complex civil litigation. She regularly advises U.S. and multinational companies on investigations and enforcement actions conducted by agencies such as the U.S. Department of Justice and the U.S. SEC. Katie has extensive experience in designing and implementing risk-based compliance programs, conducting risk assessments, and advising on supply chains, anti-corruption legislation, and anti-money laundering. Thank you both for joining us today. My name is Sarhan, a partner in our Montreal office. Focuses my practice on a number of trade compliance matters, including economic sanctions, anti-corruption, supply chains, which is the topic of this webinar here. So today we will be discussing, as you all know, a very highly topical matter in Canada, modern slavery in supply chains. We'll focus first on what that means, what stands behind the words modern slavery. We're going to discuss the recent legislation in Canada that has been rolled out. Then we're going to move to really the benefit of having Katie and Kristy, and what shows the depth and breadth of DLA Piper's our ability to showcase the international trends. And so we'll discuss legislative trends and what to expect moving forward. And we're going to talk about some practical insights, best practices, and do a case scenario. If we have time, we'll do a quick Q&A session. So we ask that you ask your questions in the chat. And if we don't have time, we'll definitely address any questions post-presentation. So let's kick it off. Kristy, we often hear modern slavery alongside the terms forced labor and child labor. Could you tell us a little bit more about what these terms mean?
Certainly, and thank you, Alan and Katie. It's great to be with you both today for this session and on this really critical topic that is really raising a lot of questions for clients, and particularly Canadian companies, Alan, that you've been advising on, but more broadly, our global clients who are really tackling these critical issues. And just to set the stage for this, when we hear the term modern slavery, this is one that's not specifically defined in law, but it's really more of an umbrella term that covers various types of forced labor, human trafficking, debt bondage, and so on. And right now, this is something, that companies really are focused on because of some of the different rules and frameworks we'll be talking about. But just to put this in context, the United Nations estimates that there's almost 50 million people in modern slavery worldwide, with the disproportionately vulnerable populations of women and children. And the modern slavery is occurring almost in all countries. And interestingly, about 52% of modern slavery is actually been estimated to be found in upper middle income or high income countries. So while there's no one definition of the types of victims, that there's a lot of different types of activity here, what we're going to focus on today relates to forced labor. And as you can see on the screen here, this is really critical to understand that this involves an involuntary work or service, and the key words here of involuntary and under threat of penalty. While we're not going to go through all the different types of penalties, you see many listed here. These are indicators that must be considered when we're talking about forced labor, but really thinking about these different forms of forced labor, whether it could run from withholding wages, withholding valuable documents, particularly around passports or other type of residence permits, even deprivation of food, shelter, other necessities, and thinking about very damaging working conditions. And these are really important to think about, these types of indicators, because oftentimes companies may think some of these indicate poor working conditions, but it's really critical to understand where these indicators can shift from what may be just considered a poor working condition into something that is considered forced labor, that's involuntary, that may have these threats of penalties. And so that's something really to keep in mind as we walk through these various definitions. And another key aspect of forced labor relates to child labor, which Katie's going to share with us now.
Thanks, Kristy. And so, you know, as we were talking about with all of this, there's two components of modern slavery: the forced labor, and then the kind of almost the subset of child labor, and really the impact, as one would gather, on children. So there, you know, like with forced labor, there are various definitions, but typically child labor refers to work that deprives children of their childhood, their potential, their dignity, and one that is, and labor that is either harmful to their physical or mental development. Many countries have explicit prohibitions against child labor. And, you know, laws recognize that children can't work under conditions that are dangerous to them. It's similar to many of the dangerous conditions you were looking at in the forced labor scenario, but dangerous to them for children in particular, it's dangerous to them in any way. So that also goes to their physical, not just their physical environment, but to their mental development and their the conditions that they'll be under that impact their socially, their mental development, etc. Children also have a right to education, and work can't interfere with or deprive them of the opportunity to attend school or combine their school experience with long working hours. And so kind of with that backdrop, the common elements we see of child labor, including under Canadian law, are work or service that's provided by a person under an age of majority in that country, and that is provided under illegal circumstances, provided under circumstances that are mentally, physically, and then socially or morally dangerous to the person, or that interferes with the child's schooling. And, you know, kind of putting this all in context too, and I know you were talking about, you know, the UN's statistics as to who is impacted by modern slavery and forced labor. In 1999, the International Labor Organization, a United States agency whose, a United Nations agency whose mandate is to advance, you know, social and economic justice by setting international labor standards, passed the Convention Concerning the Prohibition and Immediate Action for the Elimination of the Worst Forms of Child Labor, or, as we note here on the slide, Worst Forms of Child Labor Convention. And so by ratifying this convention, member states really committed themselves to taking immediate action to prohibit and eliminate the worst forms of child slavery, many of which we list here. So those are, you know, the sale and trafficking of children, debt bondage, serfdom, use of children for prostitution or production of pornography, use of children for illicit activities, or really anything that is likely to harm the health, safety, or the morals of the child. It actually was one of the fastest ratified agreements in United Nations history and has been signed by all 187 ILO member states as of August 2020. And so really this has had a huge impact on you know, child slavery worldwide. More than 152 million children worldwide, the United Nations estimated, have been affected by this convention, with the proportion of child labor falling by almost 40% between 2000 and 2016. So Alan, I think we're over to you now on the Canada Supply Chain Act.
Correct. Thank you very much for that. I think it's really helpful to frame, you know, what it is we are talking about. In the frenzy trying to meet the first filing deadline, I think we sort of sometimes forgot what the actual subject matter of the act was, as we were just trying to meet that fast approaching deadline. But now, with the benefit of a little more time, I think we can take a step back and understand that further. So I'm going to take you into the Canadian legislative landscape walk you through what happened this past year, what we expect to happen, and then I'm going to turn it back to Katie and Kristy to give us an international perspective. So, number one, this is not the first piece of legislation that addresses supply chains in Canada, supply chain risk in Canada. Prior to the recent act, Canada had already enacted in 2020 a ban on importation of goods that are produced in whole or in part by forced labor. So if the Canada Border Service Agency suspected that there were any imported goods produced using forced labor, they had the right to and the authority to seize it. CBSA, in fact, has been for a number of years conducting risk assessments to identify high-risk sectors, regions, or goods that are most likely to be associated with forced labor, and these assessments allow them to prioritize inspection and enforcement. In all honesty, there hasn't been an incredible amount of published enforcement. Recently, we've heard of a case of about 50 or so goods being held out, and we're just expecting to hear more of this. Fast forward to January of this year, which is the coming into force of the Fighting Against Forced Labor and Child Labor in Supply Chains Act, commonly referred to as the Supply Chains Act in Canada. This imposed a reporting obligation only. Sort of very important to understand that at the moment there is no specific standard that companies were meant to adhere to when it comes to risk mitigation and report. It was really purely on what are you doing to mitigate risk, and you could, for all intents and purposes, say not all that much. In fact, we had certain companies have no choice because they're just standing up their process. The contents of the report are meant to cover a number of aspects, including, most importantly, the steps an entity has taken during its previous financial year to prevent and reduce that risk of forced labor. But in addition to that, you need to be reporting on your structure, your corporate structure, your supply chain, the risk profile of your supply chain, policies and procedures put in place to mitigate risk, trainings that you've put in place to ensure your employees understand where to look for these risks, and any other sort of how you address any instances of forced labor and compensating any victims of forced labor. The report needs to be approved by the governing body of the organization, which sounds straightforward enough, but created a lot of confusion this past year as to what that means, what entity are we talking about, at what level. Public Safety Canada published guidance. The last version of the guidance was published in March of this year. But up until that point, there was a lot of confusion with respect to the interpretation of a number of aspects in the Act, which we'll get to in a second. Briefly, I want to touch on targeted entities, and I don't want to dwell too much on this, assuming that those who are attending today know whether or not they are targeted entities. But this is really a question of the devil being in the details, and you need to sit down and carefully determine if you are a target entity. So it's meant to apply to corporations or trusts, partnerships, or unincorporated organizations that are either listed on a stock exchange in Canada or have a place of business in Canada, does business in Canada, or has assets in Canada. You could already see how the interpretation could be an issue with these terms. In addition, there's a financial threshold where you have to meet two of the three financial thresholds, or numerical thresholds, I should say, that you see there for at least one of the two most recent financial years. So if you have $20 million in assets, $40 million in revenue, or an average of at least 250 employees. Again, what entities? How do you calculate the assets? And at what corporate level? These are all questions that are seemingly simple, but can be much more complicated. In terms of prescribed activities, the Act clearly says it applies to entities that produce, sell, or distribute goods in Canada or elsewhere, or import goods into Canada that are produced outside of Canada. And finally, applies to entities that control an entity engaged in any one of these activities. This definition of production, selling, and distribution caused a lot of heartache, I would say, over the past year. And the Government of Canada issued guidance removing reference to the terms selling and distributing, because there seemed to be a redundancy there and a lot of confusion. Now, the Act says what it says, and law cannot be amended by guidance. But these are some of the things that bring us to these practical insights you see on this slide over here, where there were a number of challenges interpreting the Act. We do anticipate further guidance to be issued before the end of this year to facilitate interpretation and facilitate, corporate decision making. A few other insights that came through this year. This notion of bilingual reports. This is a bilingual country. The Government of Canada recommends bilingual reports, but this is not necessarily practical or feasible for everybody. So this is a case-by-case determination. Are you operating in the province of Quebec? Are you serving a French Canadian audience? This becomes really a question that's very specific to each organization. When drafting the report, and we'll come to this a bit later with the group, avoid the desire to overstate your initiatives when it comes to mitigating. These are public documents, publicly disclosed documents, publicly accessible. So effectively, it's a public disclosure that's sort of made outside of, especially if you're a public company that's used to this sort of disclosure tempos and used to quarterly reports. This now sort of falls outside of that process, but is nonetheless a public disclosure. So use caution. Failure to report. We've had a number of clients that missed the deadline. Public safety, strictly speaking, that puts you in breach of the Act. For this first year, public safety has been accepting late reports. They have been denoting any late filers. And we still encourage our clients to report if they have realized after the deadline that they ought to. We don't expect public safety to take any sort of punitive measures this year, but it is likely that we will see that in the years to come. I've talked about approving the report and the complexities of obtaining board of director approval, especially for very, very large organizations with, say, limited Canadian activities, but still activities that meet the threshold. So planning for board approval is essential. We've seen a number of clients just been put in a bind because they had 3 or 4 weeks and they had to take this report addressing very serious issues and bring it to their global board. And I can't tell you the number of times that created some serious issues and serious internal pressure. So now we have the benefit of the time. Our next report is due in on May 31st, 2025. I would be getting that on the radar as soon as possible. And to the extent possible, to the extent you can sort of include this with other ESG reporting initiatives or other joint reports, have a look at that. Review by Public Safety Canada. So we were actually surprised to see that certain reports that were submitted and published didn't appear in the public registry. And on behalf of certain clients, we would reach out to public safety and they would provide us with reasons as to why the report was not published, reasons of non-compliances, whether to form or substance. So this is confirmation that public safety is in fact looking at each and every report. Even though you're submitting it automatically through a portal, it is not automatically published. So there is a vetting process, and so you have to very carefully look at all the requirements and adhere to them. If not a problem, if you do run into a situation where there were non-compliances flagged, you have an opportunity to revise and resubmit. Along with the report, the Government of Canada has also required companies to complete a mandatory questionnaire. This was a bit of a surprise because it wasn't referenced in the Act and only came online later. You have to answer a series of questions. They're multiple choice style questions. Some are open-ended. The key here is to make sure you're very consistent with what you are saying in your report. And again, not an area opportunity to either deviate or overstate. Those questionnaires are largely used for data collection purposes. So again, briefly, before I hand it over, my colleagues, The 2024 annual report on the Supply Chains Act was just published a few weeks ago. And as you can see, thanks to the questionnaire, they were they were able to quickly sort of consolidate and prepare these statistics. So almost 6,000 reports received by May, a number more received by July. So that tells you late filers. There were a number of late filers. Identified risks across these entities. So the Act is also applicable to government institutions. Measures include risk assessments, policies, and supplier monitoring. These are the typical mitigation efforts that companies reported. And you can see the remediation down there. What we do expect is increased scrutiny moving forward. The government was very clear in their report that there have been no orders or charges to date, and that year one, potentially year two, and we keep a close eye on this, the focus will remain on awareness and compliance and less on enforcement. But it's very clear that we're moving towards more scrutiny and more enforcement. The next steps are really to review those policies, enhance your training, and engage with your stakeholders. I'm sure many of you are already. So this is the Canadian situation. There is a ton that's happening on the global stage, and I'm going to hand it over to my colleagues to tell us a little bit what's happening and where there's convergence and divergence.
Thank you, Alan, and thank you for that overview from the Canadian perspective. And while we're looking across the globe, it's really important, as Alan said, to think about not only the jurisdiction where your company is operating, but how that could intersect with other requirements across these other jurisdictions. And the slide that we've shared here really highlights the two main categories where we're seeing so many different countries that are taking action in an increasing way. And the first set, which I'll talk about, is related to the supply chain transparency laws. And you can see here that these are growing and in their locations and complexities. And essentially the years that these cover, the earliest ones being from the United Kingdom that you see here from 2015 to Australia 2018. The US we'll talk about as that has further developed as well in the transparency space. And then on the EU side with these particular directives that are coming forward that I'm sure many of you are looking into as well, and what those requirements will be for transparency. And essentially this first category on supply chain transparency with these laws is really focused on disclosure. And essentially the disclosure is focused on the efforts that companies are making to eradicate modern slavery. And each one of these has different thresholds. I know for Canada, you saw what Alan described in terms of operations, revenue, and so on. There are some threshold requirements here, which we won't go into detail about, but just that there are certain companies that will be in scope. And this disclosure focus, it's interesting because it's actually, the laws are not mandating that there are measures taken to eradicate forced labor, but again, it's the disclosure of the steps taken to address, to look at your company structure, similar to what Alan described for Canada around disclosing policies, due diligence processes, risk assessment, and training. And these disclosures would appear on company websites. In certain instances, Australia would be an actual submission to customs authority, but it's really taking the steps to understand what companies are doing just from a transparency perspective and thinking about what steps those are and how they may be addressing these issues. The EU piece that you see here, these are newer directives in the sense that they're coming online now. The Corporate Sustainability Reporting Directive, the CSRD, is actually part of a broader sustainability reporting. So while, for example, the UK and Australia are modern slavery statements, the directive from the EU on the CSRD is part of broad environmental social governance disclosures. And for companies there's a phase-in approach, again, depending on what thresholds you meet, but that is underway, and certain transparency around the supply chain would be included if that's also material to your business. In addition, there's a due diligence directive from the EU as well that intersects with the CSRD on due diligence reporting. And more broadly, the EU also has forced labor regulation for prohibition on certain imports into the EU related to forced labor. And there's also a deforestation-free products known as the EUDR, which is more limited to certain companies that have products related to wood or palm oil, soy, and other areas like that, which also would have to be considered for potential human rights issues. So it's quite broad in terms of these types of laws, and it's important to understand which apply, taking that scope and applicability analysis, understanding the intersection of how these laws may conflict, or how thinking about what type of jurisdictions you're in and what those requirements are and what the deadlines are, and to think about the strategy overall. That's just one category. I'll let Katie talk about the second one that's listed here related to human rights due diligence.
Yeah, no, and I think the human rights due diligence category in many instances goes hand in hand with the disclosure aspects of this. So it's not just saying, what are you doing to prevent or what measures you're taking to prevent modern slavery within your supply chain. But some of the jurisdictions that we see here are going even further and saying, as part of that transparency piece, they're actively requiring countries that are subject to their legislation, companies that are subject to their legislation to take steps to undertake due diligence, specifically throughout the supply chain, in terms of where there could be risks of human rights violations, and putting measures in place to prevent against that. So France was one of the first out of the four who are listed here to launch supply chain legislation back in 2017 with the Duty of Vigilance Act. And it requires all large French companies to undertake due diligence with regard to the companies they control, as well as their controlled subsidiaries, contractors, and suppliers. So that also includes developing a plan that covers not just the company's own activities with regard to possible violations of human rights standards, what controls, et cetera, they have to have in place for that, but then also looking, throughout that supply chain as to what measures they can, both doing the due diligence, but also having a plan as to what measures they're going to take to monitor and prevent against that in the supply chain. The Norwegian Transparency Act is similar. It was passed in July of 2022. And also it's subject to larger companies in Norway, as well as foreign companies who have to pay taxes in Norway. And again, it's requiring those companies to go through that due diligence to identify and assess both the actual and potential adverse impacts of human rights and decent working conditions in both the company and its supply chain. And I think this is one of those areas, and you see this in a lot of the legislation. You have the forced labor component, but then many jurisdictions are also bringing that decent working conditions that goes even beyond, what any of us, I think, would consider horrific working conditions, to if there are even the less extreme cases that oftentimes, and I know we've seen this in supply chain investigations that we've done, that some jurisdictions would qualify more as a labor and employment issue, versus in other jurisdictions it becomes more of a violation of this decent working conditions provision. So really, again, as Kristy was saying, not just understanding what law is applicable to you, but also where are there variances across jurisdictions. Germany similarly requires all German companies, and this came into force in January of 2023. So any company, including foreign companies who have operations in Germany, as part of a broader supply chain due diligence legislation, have to implement human rights related due diligence measures throughout their full supply chain. And this goes into indirect suppliers as well as direct suppliers. So again, it's really understanding and where not just those you're directly contracting with are doing business, but where you may have exposure indirectly as well. Switzerland's a little different in that their due diligence and reporting obligations relate to the use of conflict minerals and child labor. So it's a little narrower than much of the human rights due diligence legislation we've seen in their neighboring companies, but still it requires you to go through that entire supply chain. So I think, Kristy, going to the frameworks that we're looking at here.
Yeah, we just wanted to highlight the voluntary framework, some other jurisdictions in terms of what some of your companies may already be signed up for. And so you'll see some of them listed here. For those familiar with the UN Global Compact, there's Principle 4 around principle of companies upholding the elimination of forced labor, and the OECD guidelines. Many of you may also be familiar with. These are government guidelines to multinationals to enhance businesses' contributions to sustainable advancement and addressing these adverse impacts related to environmental social governance, and of course talking here related to forced labor. And as was mentioned earlier from Katie, in terms of international labor standards on forced labor as well. So these are voluntary frameworks. Many companies have signed up. They've made statements committing to them. And for those of you who have sustainability reports, for example, that you're voluntarily publishing on your websites, and a number of you who are including references to these, it's something to also consider in this landscape of how these voluntary frameworks intersect with these mandatory laws that we've been discussing. And really overall, though, I'm thinking about how this relates from an enforcement perspective. And as Alan said, similar to what he described in terms of Canada, really across even the number of laws that Katie and I just walked through on the prior slide, as you can see here, a lot of the enforcement has been limited to date. And as Alan was mentioning, a lot of the focus has been on compliance, awareness, and raising these issues. And we'll see as this may develop towards further enforcement, but really understanding the compliance with the laws and what's required for companies is critical, because they're actually beyond enforcement from the regulatory side, the pressure, the point that we've raised here in terms of other stakeholders that companies intersect with beyond just the regulator. So a number of NGOs are very much having their eye on what companies are doing. There's been a number of published reports where NGOs have taken investigations and news articles that come out from that, which could open up questions around allegations. And so that can lead to internal investigations and other types of activities. So thinking about NGOs, thinking about other customers, even employee demands. I mean, there's just a lot of different reputational issues with that is really important to think through in terms of what the overall environment looks like. And we should mention here too, just in surrounding litigation, we were mentioning earlier how so many companies, of course, are publishing sustainability reports and making commitments on websites and other advertising, marketing materials, potentially advertising or marketing around ethical sourcing, for example, and really taking a look where certain NGOs too are filing, at least we've seen this particularly in the US, that they're filing litigation for those types of statements where they see a advertisement being made in terms of ethical sourcing, but on the other hand, may be concerned about certain forced labor allegations. So it's really critical to understand what commitments the company is signing up for, what they're publicly saying, and thinking about this area. We often hear this term greenwashing in terms of environmental claims, but the term around fair washing in terms of forced labor commitments and what companies are doing in that space is really important to keep an eye on.
I think that's absolutely right. And I think limited enforcement to date actually is an opportunity for companies to get things in order, review their policies, do their risk assessments, because we're just going to be seeing more, not less. And just like Canadian guidance, we're hearing from other regulators that at the moment it really is about promoting and raising awareness. So while we have that luxury, it's in everyone's interest to sort of get things in order and look at what risk mitigation measures are in place, or really understanding what your supply chain, the complexity of your supply chain. We're going to move now to discuss best practices for developing a global strategy. So it's not, you could look at this from a jurisdiction by jurisdiction level and it seems manageable. But when we start looking at this at the global level and for really larger organizations that have activities right across the globe, how do you streamline your processes or your policies, or do you even want to in all instances? It becomes quite a complex question. So we're going to discuss some of the best practices, and Kristy will lead us through. Katie will lead us through that.
Thanks, Alan. And yes, you're right. It is. I mean, what we're going to be talking about here are best practices, and really, it's not going to be a one size fits all approach for every business, but I think kind of the concept we'll be talking about here really can be applicable to many, if not all of the companies that are on the call today. So kind of as you kind of alluded to a moment ago, the first step is really conducting an audit. So, and that's twofold, right? That's to understand where your supply, what jurisdictions your supply chain touches, where you may have reporting obligations, what the law is in the various jurisdictions where your supply chain goes into. But then also to understand the forced labor risks that are most prevalent within your supply chain. And so in terms of the type of risks you should be thinking about, while there's no prescriptive list of risk indicators, there are a variety of common ones that are pretty universal regardless of your business line. So, geography is a major one. Are your suppliers operating in countries where there are high risks of modern slavery, forced labor, child labor? Their product or service, are you dealing with raw materials where there are known worker risks or historic instances of modern slavery? There have been some recent cases in the fragrance industry, for instance, or in the cocoa industry, and there's a variety of different other industries. I know we were talking about with the deforestation aspects of this. Are there are you operating, or one of your materials coming from a jurisdiction that has a higher risk for modern slavery? What type of work is required to make the product or to deliver the service that you're dealing with? Again, is this a more highly skilled labor force, or is this one that is often made by unskilled workers or lower paid workers, for instance? In a variety of governments publish lists of goods that tend to be made by child and forced labor that can be useful as you're trying to think through this. Your employment mode. So how are employees hired within the supply chain? Are you dealing with companies that tend to use recruiting agencies, for instance, to bring workers in? Are there seasonal workers who are brought in, or migrant workers who are brought in as part of the supply chain? Industry is part of it as well. You probably, hand in hand with products and services. Again, is the industry one that is subject to or I guess more likely than not to have a higher risk of modern slavery within the industry? What have you seen, in terms of what's happening with your peer firms in the industry? And then, this also goes to just kind of a general adverse media screening, bad actor screening that you would be doing for anybody as well in your supply chain, whether you're talking or your customers or your third parties that you're doing business with. So really kind of understanding what those risks are, and where and do the companies in your supply chain, do they have policies and procedures related to protecting against human rights violations or forced labor violations? And so kind of really understanding what the supply chain is, where it's doing business, and where you may have risks. The other big piece of this is mapping those indirect suppliers. I think that's really where we run into this oftentimes with clients is, they have decent visibility into their supply chain, but it's when you start getting into the indirect suppliers that is difficult. So part of that is just tracing through your supply chain of where your suppliers may be using, subcontracting out for a part of the product or services that they provide to you, and then understanding kind of where that is going to. Oftentimes, and as you're looking forward in terms of kind of getting more control over that, that may be having contracts, clauses in your contracts against not allowing subcontracting without written approval from the company. So you have some more visibility into that, or ensuring, putting it on your suppliers to ensure that anybody that they are hiring for you also is taking measures to protect against human rights violations. And then going forward and monitoring this, really looking at, how are you going to keep an eye, once you've mapped your supply chain and you've conducted your audit, how are you going to monitor this on an ongoing basis? And again, nobody expects perfect monitoring. Most companies don't have the resources to monitor every single company, every single supplier, every single day, but looking at this from a risk basis of, again, those higher risk jurisdictions and higher risk suppliers and indirect suppliers, how are you going out and making sure you're staying on top of what they're doing in the market? Having those updated internal policies, looking at your own policies to make sure that they are taking into account the legislation that your company is subject to, and you're educating your employees about what they're subject to and how they should have controls, and what kind of controls that need to be in place within the company, and really reflecting a zero tolerance approach to forced labor and human rights abuses. And as I mentioned, kind of integrating that into your contracts with your suppliers. Then going to the next slide, again, this goes to the employee training, making sure your employees know what it is that they're looking for, know what the red flags may be, thinking through what other detection methods you may have at your disposal, whether it's data monitoring, AI aspects, and what are the reporting mechanisms for your suppliers and those in your supply chain to come back to you? Is do you have a hotline that's publicly available? And are you taking in complaints from those outside of your company, not just within your company, for instance? And again, the cross-departmental awareness goes to looking to make sure it's not just those who may be dealing with your supply chain, your procurement team who's aware of this, but really that the company overall, and everybody, between departments, whether it's legal, HR, your sustainability teams, that they are collaborating together to ensure that everybody is looking out for red flags and they're looking at it from different angles, to make sure that you're enforcing those compliance measures. And then, and this is part of the contractual piece, having a supplier code of conduct that lays out what you expect of those that you're doing business with, including zero tolerance for forced labor. What we find very helpful and we strongly encourage clients to do is to not just require compliance with the supplier code of conduct, but actually have audit clauses and conduct regular audits. Not just having the audit clause in case you suspect that there's a problem, but going and proactively doing regular random audits throughout your supply chain in order to keep as part of that monitoring exercise. And then, particularly for those smaller suppliers that may not have the same resources that you have, is offering, training for their employees, or resources for their employees to help make sure that they're meeting your standards as well as international labor standards when it comes to labor rights education and workplace safety programs, and even just awareness of modern slavery legislation.
Great. We'll move to the next slide now. This is our favorite topic, which is the challenges of multi-jurisdictional reporting. When does it make sense, and when perhaps does it not make sense? So, Kristy, will you take us through that?
Sure. So this is a critical question as well, and just thinking about all the different jurisdictions that we just described and walked through, varying requirements, thresholds, situations that could trigger disclosure both at the annual basis or at other times when they may be required. And it's important, again, to take that multi-jurisdictional approach, understanding, again, what the requirements are across the different countries. But because more countries are adopting these, then what those requirements may look like, if there is an annual statement Should that be done at the entity level? Should that be done at a consolidated level? There's a lot of different ways to think about that in terms of your location and issues, the risk profile, as Katie said, in terms of geography and other indicators. It's really something that more companies now, because of these different laws, are trying to establish within the company a strategy to how to approach this. And essentially, of course, making sure you're meeting the criteria as we've got listed here, that is a baseline, but then how you're going to then consider having these different types of reporting that you may want to put forward. So there's a lot of different strategies for doing that, which I think we could spend a lot more time on, but I think we also want to make sure we can share some more information about this, but it's just something to highlight because of all the varying requirements across the globe at this time.
Yeah, and the one thing I'll add though is if you are contemplating enterprise level reporting, there's got to be a very high degree of confidence within your compliance function that the measures are consistent and applied throughout an organization. That really doesn't work very well for decentralized organizations or organizations that are really cross-sector organizations, because the risk profile will change. So it really requires very careful consideration, careful attention. It's nice to think you can have one report that's a UK and Australia and Canada report and the other jurisdictions that are going to come online, but sometimes that's not practical or feasible.
And the other concern, and we mentioned as well, is just that it could be that reporting in one jurisdiction may require a number of different types of details that other jurisdictions may not, and it could trigger more scrutiny on regulators depending on the type of information that's shared. So that strategy piece is really important to think through, because while the efficiency piece and streamlining is important, of course, because you're not trying to create those additional burdens across the procedural part of this, it's really also making sure you're not creating more risk in different jurisdictions with different requirements. So you'll want to take a look here as well. I can't emphasize enough the first point around making sure that there's critical eye on what type of activity that the forced labor, if those are type of allegations that are coming forward. As Katie mentioned, there's been a number of discussions where some companies may view this as simply a labor and employment issue. And there really needs to be a critical understanding of what certain activity may rise to the level of labor and employment in one country, but there could be something that's much more significant that's happening that would really take another look to put this more broadly in terms of modern slavery and forced labor. So it's really important to be focused on how you're going to approach this in terms of the compliance piece. And as we mentioned earlier, in terms of making sure you're not overstating these commitments on forced labor, what you're actually doing, because you want to make sure that, as Alan said too, it's not something that's only done in one entity, but it's really being taken very seriously across the organization. So just some points of caution here to think through as you're considering this, and just to make sure that, again, there's an overall strategy on how you're going to go about this type of compliance. Okay, so in continuing with the best practices, we wanted to share a scenario that really raises a lot of these issues, and thinking about what the factual details that could come forward that you may face, and we'll talk about from there what type of steps should be taken when you may encounter these types of allegations. And this could come, for example, through a whistleblower or other means. But essentially the scenario that we have here that we wanted to highlight, which I'll read through just to make sure everyone has the details, is essentially in this scenario dealing with a global manufacturer facing allegations of forced labor. The allegations are linked to an indirect supplier here in Latin America, and the supplier, which is part of the raw materials chain, is also a vendor for several other global brands. Reports have surfaced accusing the supplier of unsafe working conditions, withheld passports, excessive broker fees, underage workers, and restricted movement of workers. The exposure has come through here, a third-party audit, and there's been investigations by a human rights group, and it's casting a shadow on all companies that are tied to this particular supplier. So what steps can be taken in this type of scenario? And we'll talk about that in terms of where we can think about how to address these types of issues. And Katie, I'll let you go first.
Yeah, so, I think the first piece of this is, obviously you want to conduct an immediate investigation, and certainly, you're going to be, have limits potentially as to, how far you can go in your investigation in terms of who you may have access to. But, particularly when you're dealing with, as we are in this fact pattern with an indirect supplier. But the first piece I think is twofold, right? Is you want to trace through as to the extent you are able to, where this indirect supplier comes into your business, what pieces or raw materials or aspects of their product or services come into your supply chain, and then where does that go to outside of the company in terms of what other businesses could be impacted by it. You want to look at your contracts to see where you have audit rights, and this is why, as we were talking earlier, that audit rights aspect of this is so critical because it gives you the ability to go to those in your supply chain, and hopefully those through that relationship to the indirect supplier to actually look at their records and meet with individuals. Depending on how it came up through the audit and through the investigations with the human rights group, or if it comes in through a whistleblower hotline, for instance, you may have access to employees within that organization, all the better to be able to reach out to them, to be able to conduct interviews with those who are actually potentially impacted within the company. In the absence of that, I think there are many companies that I know we certainly partner with on behalf of clients who are able to do what we call boots on the ground diligence there in the region, and they're able to do that through both going and physically observing the manufacturer, through actually going and speaking to others in the marketplace on a confidential basis. Looking and doing local news and local language research as well too. So there's a variety of different ways that they can approach it, but trying to gather as much information as you can, really as early as you can as to what is actually happening through the resources you have. And every investigation is going to be a little different here, based as to your access, but really kind of at the outset, critically looking at not just the impact of this, but where you may have points of access into the indirect supplier to be able to start having those dialogues. And then also talking to the supplier themselves and doing interviews with people within the business if you have access to do that through those audit clauses. So those are just a variety of ways that you can go through it. Again, when you have those when you have access to both your supplier and your indirect supplier records, you can look at things like, how are they hiring their workers? What are their hiring practices? And then coupling that with the boots on the ground research of what is it actually looking like in practice. And ideally, like I said, the interviews with individual employees can really kind of give you a good sense as to whether there's any veracity to the allegations. So I know, Kristy and Alan, if you have other thoughts, I know there was a lot there.
I think you covered. I mean, the investigation is critical to start right away, as you mentioned, Katie, and just in terms of while that's going on, there also needs to be a consideration, as we have in point 2 here, on the disclosure obligation. So you're thinking about, if you've got a global company, which jurisdictions apply, and where do you have a statement that you've already disclosed, or you could trigger a disclosure. And so there needs to be a team that's also focused on what those disclosure obligations could look like. And the sooner to understand that, the better, because there could be immediate disclosure that could get triggered right away versus an annual reporting. But there's different, of course, considerations for that, and understanding what those obligations are, what penalties may be imposed depending on the situation. And you may not have all the facts, of course, at the time, as Katie mentioned, in terms of how that investigation is coming along, but also if there needs to be reporting up through with senior management, executive, board level, just what information is required, and companies typically will immediately want to understand, what is the disclosure piece while the investigation is going on. So that's a critical component simultaneously that's happening. And then there's the third part, Alan, in terms of the last piece here, in terms of action and remediation from there.
Yeah, so just a really quick point on the disclosure, just an example from the Canadian perspective, and I'll move to point 3. So this would be, from a Canadian perspective, the difference of a Customs Act, customs tariff violation, whereby you're concerned that an actual good was produced by forced labor is now potentially entering the country. So do you disclose that immediately? Do you halt import of those goods if it's determined, or if there are some serious concerns that they may be made by forced labor, versus how do I address this in my annual report? So perhaps the good did not enter Canada, but somewhere in my supply chain there is an issue. And that would be something you would address at your annual reporting under the Supply Chains Act. So a very good example at what we mean by different types of disclosure. We've just got a couple of minutes left. Obviously, as with any compliance breach, corrective action and remediation is crucial for the good health of any compliance organization. So it hasn't amounted perhaps to forced labor or child labor, but there are some serious concerns about how things are being run. You work with your supplier for remediation, you help them improve the working conditions, you rectify whatever issues are necessary, you put them on a clear path to improvement. These are, I think, instances where things are salvageable, the relationship is critical and it's salvageable. On the other extreme, things are really not salvageable, very problematic. Do you consider disengagement? Do you have the right contractual means to sever ties as well without incurring liability? So going back to what Katie was saying about building the right safeguards contractually to ensure a graceful and ethical exit, all the while not harming some of the workers involved. So that brings us just to time. We've got 2 minutes. I have time, I think, for one question. Actually, I see there's a question that's come in. And the question is, how can we tell if our, I get this is a Canadian specific question about the report. How can we tell if our report was published from last year's submission? So good question. Public Safety Canada maintains a catalog on their website, and you just click, if you go to the forced labor or the modern slavery splash page, there's one of the tabs is very visible. It's called Library. So you just click that and you do a search for your company name, and you should find it. If you don't find it, perhaps it is not published. It is not the most user-friendly, so try different permutations, different names. But the reality is, where public safety does not publish reports, in our experience, they actually send emails to the individual that submitted the report on behalf of the company, explaining to them that it was not submitted and providing, perhaps not in the clearest terms, but providing or suggesting reasons for the non-compliance. So that answers that question. There are a couple of others, but we've run out of time, and we can address those post webinar via email. Katie, Kristy, thank you so much. It really sort of enriches these sessions for our Canadian clients to have this amazing depth of expertise that could speak to global trends. Thank you very much, and thank you all for participating. I hope this was helpful and useful. If you have any questions, please do reach out to any of the panelists here, and we look forward to continue to work with you all.
Thank you.
Thank you.